Hello, and we are live. So welcome to everybody who's joining us today for this episode of Let's Talk Data. For those of you who don't know me, my name is Tracey O'Neill. I'm a data consultant and the founder of a company called thedataconsultant.ie. What I do is I help customers use their data to grow their businesses. So in the course of my work, people often ask me questions about how to use their customer data and what is a GDPR compliant way to do things. So I often say, ask the expert. So we've got an expert in the room today. And so I'm going to introduce you to Eileen Ireland, who is a GDPR consultant. So I'll let Eileen give a little overview for herself as well there.
Perfect. Delighted to be here, Tracey. I'm going to start off as I start off with every event that I do. Anybody who knows me knows I have a dog. So if you do hear barking, it's just the dog likes to get on every recording that I have. I work with all areas to do with GDPR and data compliance. And me and Tracey are one of those kind of, couple of people who love data. I love getting into the nuggets of data. I love how you can use data for your business, how it is really beneficial. I'm also very much aware that people are frightened and unsure how to use data and GDPR together and how they can combine it. My motto within my organization is taking the fear out of GDPR. You do not need to be scared of it. I think you just need to be aware, have a little bit of knowledge, a little bit of understanding, and ask the questions to yourself when you have data in front of you. So that's kind of where I come from on this.
Brilliant. Thank you, Eileen. So just to give people a bit of a flavour, we have people from all different sectors actually on here today. So I come from a recruitment background, so we have a lot of people from recruitment organisations, but we have some people on here, I think, from manufacturing companies, software companies, I think some from hospitality. So what we're going to do is keep this fairly broad. The principles are all going to be around customer data. Again, we're specifically talking about GDPR, but Eileen and I are both based in Ireland, but we do have I have some clients in the UK. So hopefully all of this will apply to everybody. But as we always say, if you need specifics or you need something, for your own company or have particular questions, contact Eileen or contact me directly. In terms of how we'll run it, we're here for an hour. We have a lot to talk about. So I have gathered, I think, 5 or 6 questions from my clients that come up most often. So we're going to just sort of run through those. Eileen can give her thoughts on those. And then we'll probably have maybe 10 or 15 minutes at the end for people if you wanted to drop questions into the comments box, and we'll see if we can answer some live questions at the end as well. So without further ado, the first question. So what I do with businesses, so when I go into companies, the purpose of me being there is they've lots and lots of data, lots and lots of customer data, and they want to use it in a commercial way. So they want to obviously use the data to make money. So the first thing that I'm doing is I'm looking at the data, because we want to typically put sales and marketing activities around the customer data that they have. And oftentimes people have tons of data, like tens of thousands of customer data records. And when we start looking into that, and when we start segmenting, whether it by geography or by product or, by customer type, the question often comes up, can we keep all of this data? Do we need all of this data? And then conversations come up about retention policies and data protection and so on. So oftentimes I speak to people who have data going way back. 10 years ago, this data has arrived on people's databases, and that predates GDPR and legislation. And I know privacy was always a thing, but definitely predates GDPR. So I suppose the first question is, if somebody has 100,000 records on their database, how do we start talking to those customers about the fact that we have their data? Is it too late to do that, or how do we start that process, Eileen?
No, it's never too late. It's never too late for anything to do with data. And we all have those customers. Like I worked in insurance for years. We all have those customers that have so much data, and you kind of go to them first and you go, oh my good God, like, how am I going to organize this? So first of all, what I would say within an organization, you should always have a period of retention. Like you should have a period of retention document. It's part of your GDPR program. And when I'm working with clients, I always say to them, okay, there's a couple of things I want you to do. First of all, I want us to put some boundaries around the data that we're holding. You cannot just hold all the data forever because it works, it suits your purpose to do it. Or secondly, you are keeping it because you don't know what to get rid of. Like that's no defense anymore. So what I would say to people at the very beginning when I'm working with them and go, okay, first of all, in your particular industry, in your particular business, are you part of a regulatory authority? Are you part of any regulatory bodies? Are you part of any associations or you know, national kind of guidelines that that you are registered with and you're a member with? Because if so, like, for example, I would know, because I've worked a lot with the IACP who do therapy, who work with therapists, they would have a very clear definition of how long you should be storing client data for, client records for, things like that. So they would give you a clear idea policy-wise. And I would then say as well, if you are not a member of any of those accredited boards, look at your insurance policy. Your insurance policy might clearly state how long you should be storing data for as well. Thirdly, if you don't have that, look at your privacy policies. Have you got any privacy policies in place which clearly outline how long you should be storing data for? And if you say, well, I do have a privacy policy, but it doesn't state it, that's fine. We need to put something in. What you need to do with your data is you need to start dividing up your data. You need to start looking at dates for your data. How was the data achieved? How was it retained? Was it through a financial transaction? Was it through somebody expressing an interest in your products and wanting to follow you or going on your mailing marketing list? Accounting wise, they have their own regulations. Obviously, we're based in Ireland and pretty much the UK has the same as well. I say for everybody, anything accounting wise is generally 6 calendar years. I say 7 just to kind of cover the crossover period. So after it gets over 7 years, you've got to look at it and say, I've got no legitimate reason for keeping this data. So always as an organization say, okay, how long do I want to store data for? How long would be long enough before it becomes excessively, you know, you're keeping it for too long? So 100% break down your data, divide it up into how you've obtained that data, through what method, through what kind of transaction with the client or a business. And then say, okay, is there any regulatory responsibility, any regulatory guidelines I have to adhere to on this? If not, what is realistic for me? Policies. Yeah,
somebody's just mentioned there in the comments, and it was a question that comes up to me a lot as well. Is there a specified timeline? I mean, is it, you know, the data retention in people's data privacy policy should be 2 years, 5 years, 10 years?
Depends on your industry.
Okay.
Yeah, it depends on your industry. What I would say, like, and I've worked with so many different people because I do privacy policies and things like that on websites for people. And when I'm working with them, I always kind of know generally the industry I'm working with, what their kind of guidelines with, just because of history of working with them. And I would say, as a rule, you know, if you are doing a physical product, you've got to remember underneath the Sales of Goods and Services Act, you've got to have a physical, if your product breaks or if it doesn't work within that length of time, you can go back and contact the company. So I would always say, if you're doing a physical product, absolutely do something kind of for 7 years. If you are doing anything kind of accounting wise, generally 7 years. I've come across people who do cosmetology and laser therapies and beauty treatments. They could be 10 years that you're keeping client records for. I've come across stuff where you're doing therapy in industries. They are generally 7 years if they're adults. If they're children, it can be 7 years once that child reaches adulthood. So you're talking till the child is 25. So if the child is 2 and they're with you, or 3, you're keeping it until that child's 25. But you have to be very clear about your industry. If there is any particular guidelines that you should be following. If you are unsure, get in touch with me and we can have a conversation, because I can steer you in the right direction, because it could be one I've come across before.
Yeah, perfect. In a lot of the companies that I work with are service industries, and as I mentioned, particularly sort of in the recruitment industry, and there is sort of this idea that as long as you're engaging with your clients, so if there is an engagement, there's an ongoing engagement, whether it be, you know, your customers, your applicants, and so on, you know, that once an engagement is proven, that's fair enough. You know, you can kind of retain somebody for that. So let's say, give you a perfect example. Some of the policies that I see say we'll retain your data for 2 years minimum after our last meaningful engagement. And engagement could be phone calls or emails and so on. Does that sound about right to you?
Yeah, that does sound. I wouldn't be annoyed to read that. I think that's actually quite realistic. A period of retention only kicks in when you finish working with somebody, or when you last have contact with them, especially in an industry like yourself, that can be very transitory. That can be very, the onus is on the person who has put their information on like a CV or something like that on a job site, or, you know, whatever industry you're in. If they are the one that's making the effort and putting their information on a platform, and you are engaging with them, absolutely, and they're coming back to you. But what I would say is that once somebody stops like working, say if you've got a portal, or if you've got a platform that they create, or if you've got any kind of mechanism where they create a membership, where they create an account on your platform, and once they stop using that and they haven't used it, and it's been maybe it's gone, you know, you're no longer using it anymore, I would say after 2 or 3 years, then you can look to close it down, because you're holding information then when obviously the person is no longer engaging with you. So just a good point to note that the period of retention only kicks in once you finish working with somebody. And that is the important bit to ask. It doesn't start when you're working with somebody, because how long is a piece of string? You could have a relationship with somebody for years. It only kicks in at the very end.
Okay, so if you, for example, you had in your privacy policy, you know, we will retain your data for a period of 2 years, as long as we're engaging with you, and engagement means phone calls, meetings, transactions, and so on. Broadly
absolutely
speaking,
I always say, when we're creating any kind of policy, any kind of form that you're providing information to somebody, transparency is king. Be mindful of transparency, be mindful of speaking in very clear, understandable language, so that there's no confusion or ambiguity about what you are meaning and what you are saying. So absolutely. So when you're doing privacy policies, 100%, I would always put into a privacy policy your data retention.
Okay, so if we're kind of circling back then to the start of this particular piece, and we're saying we have customers who are on there from 10 years ago, and we're not actually sure where they came from, potentially, is it okay to get back in touch with them and say, look, you know, we're making some updates to our policy, you know, here's a further link to our privacy policy, let us know if you don't wish to, you know, continue to be on our database or whatever.
Okay, I suppose it depends. It depends how you're contacting them. If you're contacting them kind of through, say, a MailerLite, a MailChimp, an ActiveCampaign, a marketing platform, absolutely you can say that, because you can say to them, if you don't want to receive any more correspondence from us, you know, unsubscribe. You know, or you could say, we're updating our data protection policies, our GDPR data retention, and we just want to make sure that you're happy to receive information from us. So absolutely, I would put everything through one of those kind of platforms, because it allows somebody to unsubscribe. Because the onus then the other way is you're wanting somebody to come back to you and reply to an email. And how many emails do we read that we go, do you know what, I'll go back to that later. I'll go back to that later, and I don't do anything with it. But 100%, as long as you are proactive about it, just don't leave your data sitting there. There's no point, and I say this in all of my trainings, there is no point having 10,000 pieces of data on any kind of list if you are only ever getting engagement from 500. The other bits aren't worth anything to you. So kind of tidy it up a bit, put a bit more organization into it, contact the people who you haven't had any engagement with and say, are you still happy to receive emails from me? And did you know, by the way, I am updating, I now offer these services and I didn't offer them before.
Yeah, no, perfect. And that actually ties nicely into our next topic. And somebody has asked a question here about capturing consent for processing rather than just having it in your data protection policy. So one thing that I'd really love to address on this webinar is people sometimes get consent for processing mixed up with and kind of, you know, they add the two things together. So consent for processing and consent for email marketing. So am I correct in saying that the two things are separate?
Yes.
And that consent for processing data. So if I have customers, so let's say one of my manufacturing companies, for example, one of my clients, and they have, you know, a number of customers that they have on their database, that's fine. So they're just recurrent customers and they're there and they do business with them periodically. Separate to that, they might have some of those people signed up to a newsletter and they're offering them an opt-in to, you know, to sign up to the newsletter. Are the two things are separate, and the main question here is, do you have to have specific consent, like opt-in consent to be processing data, or if you get customers onto your database through a transaction or forever or whatever, is legitimate interest enough? I know that's 10 questions.
Okay, so let's break. Let's take a big death and break this one down. Okay, so let's look at the first model of people who are your clients or who kind of you have an ongoing relationship with. Absolutely, legitimate interest applies in that part, but you can't just spout legitimate interest for everything, because some people like to use it because it can be a very wide term. Yeah, I always say the best way to know whether legitimate interest applies in this is, if I was the client, would I expect my data to be used in that way? Okay, and there is an assessment and a couple of ways of testing the theory, if you want to say, on that. So there are kind of steps to take. So absolutely, you have a legitimate interest in the fact that you can say, okay, they were maybe they bought an alarm from me, a house alarm from me, and now I might be upgrading it because I might have sensor lights or I might have different things. I've got the right to tell them about that because of the legitimate interest of our ongoing relationship. You don't need consent for the processing of that. Consent is always, you should only ever rely on consent for marketing purposes. You should never use consent as the only basis for processing data. You should always have it with something else. So if somebody has been a client with you, then you've obviously got a contract with them. You know, so you've got a lawful basis for actually processing their data, and you can keep on processing their data until they contact you and tell you to stop processing it. And then that is a separate thing. Now, in relation to marketing mailing lists, I always say the marketing mailing lists are people who have never actually got that contractual relationship with you, so you can't claim legitimate interest in that. They might have said, oh, I see you do alarms. You know, I might sign up to find out more about it. I might look at your website and sign up to your marketing list. I'm not a client. I've not arranged, I've not expressed any interest in your products. I've not had that contract with you, but I'm interested in your kind of thing. That is when consent comes in. So again, if you use one of the established marketing platforms, and I've got no affiliation with any of them, and I would say, then you have like a double opt-in. That's your best practice. So I say to you, Tracey, I'm interested in what you're doing. I'm going to click on your link to sign up to your marketing list. I will then get an email that comes to my email box. I then click on that, and that's my double opt-in. So anytime then you communicate with me through that platform, i.e. be a newsletter or whatever way you're sending it to me, I can unsubscribe then. I can take it out. Whereas when you're doing it with the other companies, the people who are using, you have that established relationship with, you know, you don't have to jump through those hoops with them.
So let's come back to the email piece in a second. But
Mm.
even if we stick with this now, so when you're adding new customers to your database, I kind of talk about, you know, sort of good practice and red flags. So with my clients, I say, once you're adding somebody new to your database, it's always good practice to send them a welcome email and say, you know, we've just engaged, we've just spoken to you, here's a link to our privacy policy. If at any point, you know, you would prefer us not to retain your data, email us and let us know. Would that be sort of a good practice, sort of at a base level for people to do?
What I would suggest is, as a general rule, yes, that's a great practice to have. But rather than the document I would send to people is probably something like a data protection policy, because it actually breaks down how you want handling data within your organization, and also the rights that the new customer, client, supplier, whoever, what their rights are. Because if you are a client with somebody and say, you know, I'm working with you, and you send me that email, and then I go, wait a minute now, in the middle of our transaction or at the end of it all, I want you to stop my data, I want you to get rid of my data. You can't get rid of it, because you have legitimate reasons for keeping it. So what you can say is you can stop processing it, but you are still going to have to retain certain information, because you've got financial obligations, you've got maybe legal obligations, you've got insurance obligations. So what I would say is, I would say to people, here is my data protection policy. It outlines who is responsible for what in the organization, what you're going to be doing with the data, how you're capturing it, and also the rights of the people that are looking, that you have engaged with.
So I know a number of people, so when I say that kind of thing to my clients, there's a sharp intake of breath and people go, oh, we don't want to frighten our customers off by sending them policies and legal documents and whatnot.
No, because they don't have to sign it. It's, no, they don't have to sign it. Like, think about it. Well, we take out car insurance, home insurance, things like that. We get policies, you know, and those policies tell us what our rights are and tell us, kind of outline kind of what we do in event of situations. Nobody wants these situations to happen, but we need to know about them. So it's the same thing. Like, you're not asking somebody to sign that. You're just saying to them, these are your rights. This is what I'm doing with your data. And you can adapt it very much to suit your organization, as long as you keep the rights of the subject, the person, as long as you keep their rights kind of accurate. And also, more importantly, let them know who they can contact if they've got any issues. That's the big thing. Make yourself approachable, make yourself open to them, but also say, this is what we do with your data, this is why we do it, this is how you're working, we're working with your data, but these are your rights as well.
Yeah, okay, perfect. So I have then, in terms of good practice, if customers arrive onto your database through a third party, so I'm thinking again of my recruitment clients, but I'm thinking of my hospitality clients as well, where they might have guests coming through a booking engine or something like that. Is it always kind of good practice? So if I land, for example, if I'm sending in my CV and I'm sending it in through a jobs board, I don't necessarily know that my CV specifically is ending up on a particular agency web database, right? And I had calls recently when I was doing some investigation on this. I looked at one of the jobs board terms and conditions, and they said, yeah, we as the jobs board keep your data as you would expect it. How the third party, meaning the end recruitment agency, deals with your data is not our business. So it prompted me to think, okay, well, as the end person where the CV is ending up, we need to think about that and just kind of make it clear to people where their data is arriving. I mean, what you said before actually just prompted as well, you know, it shouldn't be a surprise to anybody. So my people who work with me will hear me saying, if a database was hacked, unfortunately, and published in the Irish Times, would a person be surprised to see their name on your database? That's my rule of thumb, you know.
And absolutely, and that's the way of looking at it. What I would say is, I would look at it two ways. I would look at it both as me submitting my CV. So I'm submitting my CV into Tracey, and you got my CV because you're a platform, and then you farm it out to, or different kind of companies come in and say that person matches up to our criteria. What I would do then as this third party is I would then get in touch with Eileen and I would say, we've received a copy of your CV through so-and-so platform. We are using it for so-and-so. It's in relation to this job or whatever, that kind of thing. If you would like to be maybe added to our database, or if you would like to go to our mailing list, this is where you're there. So I'm, as Eileen, know that this third party is going to have my data. But I also would say that the middle ground, the Tracey in this, the kind of, intermediary, I would say, I would look at that and say they could quite easily be a lot more transparent about that and just say, we are storing your data from here. Because don't forget, when a person uploads a CV, their CV can be forwarded by the platform, but also the CV person, the job applicant, can be applying for jobs that are on the website. So I would be saying, that your information can be used can be accessed by various different platforms, and that you should always be aware of your data and who has access to it. And also, lastly, if you don't want your data to be shared outside of this platform, let us know. Things like that, respect the data that you're getting, respect the person because it attaches to a person, and just kind of don't put yourself in a box and kind of go, it's not my responsibility, it's someone else's responsibility. Let people have options. Let people know if they're not happy with it, what they can do with it. So absolutely. I've come across, because I've worked with a few different kind of HR companies, and I've also worked with people who provide services to HR companies, i.e. job coaches. It could be maybe psychometric testings. It could be different things. And I say to them, okay, so I'm working in a company and you've come across and suddenly you're contacting me about an interview for a job coach, or, about maybe some kind of job skill. I don't know how you have my data. How have you got my data? It's in relation to the person who has shared it with her should have made it very clear at the very beginning that my data could be shared and who it could be shared with. So 100% at all stages, I should know who has my data and where it's being shared.
Perfect. That leads on nicely to another question. Actually, I came across this in two scenarios recently with two different companies. So the company that I was working with had acquired, let's say, a subsidiary company. And the question is, can the company A automatically contact the customers of company B?
It depends. I've come across that situation. It very much depends on what industries they're in. I've come across a situation where somebody bought, I kind of was working them in a very loose sense. They purchased a platform, purchased a company, thinking that, God, I'd be able to get a hold of all of that data. But actually, the company that A was working in could have been, say, insurance. And the company that they purchased could have been offering holidays. Completely different industries. You cannot transport one amount of data to another. So I absolutely, I would always say no. But what I will say you should be doing is that when that transfer is taking place, the people that are selling, that maybe are being bought over should be saying, we are being purchased by company C. Company C are taking over our kind of marketing mailing list. They could be in the exact same industry. They might just be in a bigger umbrella. They will have access to your information. So you will be hearing from company D. And that is fine. But what I also would say, if you are company C and you are being purchased by somebody else, I would then say, this company, they may get in touch. They do not have access to the database, but they are linked on here. And if you would like to know more about their services, then get in touch with them. I wouldn't automatically transfer data over if there's not already an established link and relationship between the two industries. It doesn't happen as much, if you understand what I mean. Like usually a company is usually either merging with a similar company or is being taken over by a bigger umbrella of a company. So there usually is that tangential kind of link already there. It's unusual for somebody to just want to buy somebody else to get access to their data. Those kind of days I don't think exist anymore, or I'd like to think they don't exist anymore.
Well, talking about days that don't exist anymore, a couple of big red flags for me, and I'm thankful to say it has not happened in a number of years. But back in the day, big red flags for me about how data ends up on databases, where if a salesperson arrives from another company with a list of 500 contacts on an Excel spreadsheet and says, hey, new employer, here's a list of my old contacts, we can upload them all onto the database. And I am saying, don't even go there. Don't even touch it with a barge pole. Would that be fair?
100%. My red flag would be permanently flying on things like that, because I would look at it a couple of ways. And again, I worked in insurance and claims for years, so I always have a very suspicious mind about a lot of these kind of things. And I always would say, okay, if somebody's coming to you and they're bringing you data from a previous employer on their on a list, firstly, what relationship did they leave their previous employer with? Secondly, they stole data from their previous employer, and that's putting you then, they could be putting you then in a very tricky legal kind of criminal issues. Thirdly, you don't know what relationship that salesperson has with those people on that data, on that database. Like, we can all create a database and just kind of put things on a spreadsheet. No, I just basically wouldn't. It's not something, but if this person is trustworthy, if you know them, if there's a really good legitimate reason, like, maybe the other place went out of business, things like that, life happens. I would say to them, no, they're your contacts. Why don't you contact them and let them know where you're working now and indirect them into us, kind of thing. Ways around it, but I always say, listen to your gut instincts on these things. If something is too good to be true, it always is. And protect your own position at the end of it all. Yeah,
definitely. Somebody has just sent in a question, and again, it kind of leads on nicely. So we've kind of talked about how do we make sure that everybody who's existing on our database we're happy that they're there. We've talked about what good practices are for new people coming onto our database. And now we're going to kind of circle back around to that conversation there about how to activate your relationships with your customers. So CRM, customer relationship management, in my opinion, engaged contacts and current contacts are much better than having 100,000 that are just sitting there, and with a bit of luck someday, we'll do some work with them. So the question that has come in, let me just read it out. So the question that has come in says, I was recently asked, if you have an email list that is several years old, can you contact them via email nurture campaign and ask them, is it okay to add them to a marketing email list? They also said that they asked the email recipient to opt out of marketing instead of opt in. So there's two bits in that. We'll deal with the first bit first. So if you have an email list that's several years old, can you contact them to ask them to be added to the marketing list? And that leads into my banner question here, which is, do you have a good rule of thumb to differentiate between transactional and marketing? So if my client asked me that question, I would say, if you've been working with them and you're having a conversation about the current business relationship, it's okay to add at the end of that email, also, if you want to sign up here, click on this link to be added into email marketing. But that's what I would say. And that's why I refer people to people like you. So yes,
no. And I suppose I'm going to break that down into a couple of things. And I'm going to break down to the people that we know. Okay.
Yeah.
If you have a personal relationship with somebody, is that personal relationship based on kind of years of business working relationship? Have you kind of worked together? If that's the case, then you can require the legitimate interest. Kind of the person would expect their data to be used in that way. And you can say to them, and you can always have that if they want to be added to your marketing mailing list. Absolutely, you can have that at the bottom. Everybody can have that at the bottom of their email, like, as a footer on it. That's fine. So I'm not worried about the people that you have a personal relationship. It could be a personal business relationship. You know who they are. You've worked with them. You've established relationships over the years, things like that. I've got no problem with that.
Sorry,
in relation,
I'm just going to ask a quick question, sidebar. when you say personal relationship, do you mean my business to business relationship?
Yes,
So
it can
my
be that,
company's
absolutely.
relationship with your company,
Yeah,
or
it's
with
like,
okay.
yeah, if you know who they are, basically, if you know who they are, like I might know who, like we would have a business to business relationship, and we could also have a personal relationship, you know. So you wouldn't be surprised if I was contacting you, the email wouldn't be going, oh my God, how did she get my email? Like, how did she know this and that kind of thing? We would have had a relationship and a kind of we've established a platform as to how we communicate. So I'd have no problem with that. Marketing, an old marketing email list, what I would do, or an old email list, I should clarify. What I would do with that, I would say, first of all, are you 100% confident in how you gathered that list? Is that list, like, did you gather it with consent? Did you just get somebody to sign a name on a form when they attended an event? Did you get, was it made up of a sign-in sheet for somebody at some training course? Was it that somebody expressed an interest in your products and would like to know more at an event you were at? How did you how did you gather that information? And if you are not confident and cannot 100% say, actually, they asked me to be added onto my mailing list because they'd like to know more about me, then I would start to break your list down. So you could have a list of 100 names, and you could say, do you know what? All of those 20 names there, I know I got them to sign up at an event to find out more and to be added to my marketing list. So that's fine. You've got that there. The other 80, God, I'm not really sure where I got them from. They're a mixture, an amalgamation of everything. And we all have that. And what I would look at that and go through the list and say, okay, is there anything that's a generic email, like info, like hello@readgdpr.com, or your email address, where if I Googled it, I'd find it, you know, then that's in the public platform. But if it's kind of Eileen@readgdpr.com, that's not in the public platform. So nobody can see that. So I would look through the email list and just say, do you know what? I'm not sure how I got that email from. So what I'm going to do is I'm going to send every one of them an email. Obviously, email etiquette, and I say this every time, BCC people, do not CC everybody because you're in data breach territory, and that's a whole other call. So BCC everybody and just say, I'm updating my mailing list, or I've got your information here. I'm just cleaning up my list. People don't mind, like a bit of honesty. There's nothing wrong with that. And say, I'm just wondering, would you like to know more about my products? Would you like to be added to my mailing list? If you would, please click on the link below. If I don't hear from you within 30 days, I will delete your information. And then watch the people that are moving over and signing up to your platforms, like the platforms that I mentioned earlier, you know, and then start deleting those that have moved over, start deleting them from that sheet of paper that you've got. The ones that you are left with, you are going to bin, because unless you can confidently say, yes, they consented to my emails, you don't have the right to add them because you've got no legitimate interest in it. You've got no transactional relationship with these people. And I've had situations where I've had people contact me and they've said, oh yeah, you know, here's this event, that event, or whatever. And I would go back and say, well, can you show me where I consented for you to contact me? You know, and it was kind of annoying because it was repetitive. And they were like, oh, you would have been at some event. I said, yeah, but can you show me where? Where did I consent for you contacting me? And then they came back and went, oh, right, okay, it must have been just your name was added accidentally to this list, so we'll take you off our list. Now, everybody was probably added accidentally to that list. I was probably just one of the few that brought it up. And then I would have had other situations where I would have seen somebody sending in a newsletter-like email, and they would have, and I would have gone back to them and I've tried to unsubscribe. You know, and I've hit the unsubscribe button. It's told me I've unsubscribed. Following month, the same person comes back to me again. And this happens 3 different times. I then contact them and say, because I know this person, I said, is there an issue with your email marketing list? And they said, why? And I went, because I cannot unsubscribe. You keep emailing me, you know, and the person then came back and said to me, well, why do you want to unsubscribe? You know, and I just was like, you know what? I'm not a violent woman. But you've driven me to this because you're not respecting my rights. It's not a personal thing. It's just I'm trying to clear up the spam that's coming into my email box all the time. And what happened was that someone explained to me in marketing afterwards, they just copied and pasted it month on month. They actually never used the platform the way it should be used. So, you know, respect the data that you have in front of you. As I say to everybody, it's like your personal DNA. Unless you are confident that the people have given you the consent to contact them, do not add them to any marketing list, but email them and ask them. In that relationship, consent is king at all times in that relationship.
Two things actually. First thing is, my clients often say to me, the Data Protection Commissioner or the Information Commissioner are not going to come and audit us because we're too small, and sure, they've Google and other people to be looking at. And my point always is, it takes one disgruntled email recipient to report you, and an audit comes down on you very fast. So, you know, I think provide making sure that your lists are clean, you know, just make sure you have your ducks in a row, because it's very, 100%. Very easy to annoy somebody in that regard.
And people don't realize, you kind of think, okay, somebody's going to knock on my door and say, I'm auditing you tomorrow because, you know, I work from home. This is my business address. I'm auditing you. That's not how it works. As you said yourself, it's one disgruntled person. And I work with loads of organizations where they've actually had to work with the Data Protection Commission and the ICO in the UK because someone's lodged a data breach, or because somebody's lodged a data subject access request with them, or somebody's made a complaint about this and that. That then brings them into your, you know, they bring them into your arena then. That's how they start to get to know you. And like I had, and this is just a really quick thing, I had an email. This did happen to me, and I cover it in my data breach training. I had Bank of Ireland, and we would all know them, huge bank for anybody in the UK, huge bank here, one of the main banks. And they sent me a mortgage email with an attachment about my mortgage rates, and I was doing changes to it. They then sent me, I opened it, it was for somebody else. It was for somebody in Cork, which, to make it worse, as I say this all the time, they're getting a better rate than I was getting. So that's what kind of hit me first of all. And I then went back to them and said, that's not my information. You shared somebody's information with me. And they went, yeah, it was wrong. I just attached somebody. I just did an attachment. I went, yeah, but if you've shared theirs with me, who have you shared mine with? You know, and you shouldn't be able to do that. And so what I did then, a lot of it was because of the flippant attitude. They didn't really care. I then reported it to the Data Commissioner. People say, why did you do that? What happened to it? I said, yeah, but I'm one person. There could be 100 other people that's happened to. And it's not that they're going in to audit them based on just doing an audit. They're going in to audit them because of the amount of complaints that they've had with data. So you've got to be aware of that.
Yeah, no, I think that makes sense. So I think we've kind of covered now. So we've covered how we kind of regenerate people, how we kind of create, you know, the commercial relationships. The rule of thumb for me is probably, you know, it doesn't have to just be about email marketing. You know, there are sales activities here as well. Lift the phone, talk to people, engage people, you know, on LinkedIn, you know, do all of, you know, these good things. If there is a relationship, then, you know, as you said, I don't think people would object to hearing from you. One thing that I see a lot, not a lot, but it comes up from time to time. So I often would have clients, and it kind of comes into that whole thing about the audit and the privacy policies and so on as well, right? And I would have clients who are pitching for a piece of business, and the person that they're pitching to, the company that they're pitching to, is asking them about their privacy policies and retention periods. And then they're asking them things about, you know, are you a data controller, a data processor? Do you have any sub-processors? And about data processing agreements. And then because I'm one, and, you know, so on. So the other thing that I notice is people sometimes think about data processing agreements in terms of the software that they have that they're using to hold the data, not necessarily about the people. So for me, for example, I'm a third party working with a client's data. I would always have a data processing agreement in place to cover myself. So could you maybe just give people a sort of a high level about what they are, when they need them, some kind of important points about that?
Absolutely. This is actually one of the topics that is so underrated and so unknown in organizations. And we all have organizations and we all are part of it where you have contractors, where you have consultants, where you have people who are not employees within the organization involved within our business. I work in another hat. I work as a virtual assistant and I help manage people's offices. And when I work with them, I'm getting access to all their data. I'm getting access maybe to court reports. I'm getting access to loads of different stuff. But I have a data processing agreement in place, which means I then have a legitimate reason for getting that information because I'm carrying out a contract. I am very clearly defined my role. I'm very clearly defined about sub-processors and subcontractors and all of that kind of thing. So what is a data processing agreement? It also can be known as a data processing addendum. It's the same thing. What it is basically a contract between yourself and another party. This other party you are sharing personal and or sensitive data with. Name, phone number, email address, could be IP address, it could be CCTV, it could be reg numbers, license reg numbers, it could be medical information, biometric data, all of that. Basically, you are sharing personal data. And that person doesn't have the right to have it because they're not an employee. In an employee, as part of your role, you need to have that data to carry out your role. When you're a contractor, you don't have that employee contract in place. So what you do is this agreement then is basically outlines that you in your organization are the controller. So in my organization, I control all the data that I have. I might outsource my social media marketing to somebody. I might outsource my accounting to somebody. You know, I might outsource loads of different things. And they've got access to my personal media accounts. They've got access to my accounting records. They would see invoices. They would see payments. They might be using my email to contact people. They're all getting access to personal data. So they need to have a data processing agreement in place. So 100%, they are hugely vital. You will have certain relationships where you have two controllers. Not everybody needs to be a processor. If you're doing a joint, like if the two of us were doing a joint project together, you might be doing certain area and I'd be doing certain area. We are both joint controllers of that data, but it's no harm to have a data processing agreement in place. It reassures the relationship between both people, who was responsible for what. So say, for example, me as the controller, if I had a data breach, maybe an employee went off and stole a computer, you know, and went off and it wasn't password protected and things like that. I then have to notify my processor, the person I'm working with, that this has happened in case they are, you know, compromised by that activity taking place. And vice versa, like the two of us have to help each other out. It's a legitimate contract that's in place. And when I'm working with clients, I'm always putting in data processing agreements. Like ones at the moment, somebody's outsourcing bookkeeping, so they're getting one in place. Somebody's doing social media marketing. Another person is doing HR. They're getting it in place. It generally, for a lot of my ones, is for people that are there. Because a lot of the times the platforms that you're using, say the Salesforce of this world, all the CRM packages, when you look at their websites, they've already got data processing agreements on their websites. So what I do is when I'm doing you download them and you store them. As you say,
okay,
yeah, absolutely, because they're not going to sign it. Let's be honest.
yeah.
I can't send, little old me in Ireland isn't going to send big Salesforce and things like, could you sign my little form, please? No,
Yeah.
that is enough. That is enough for it, because don't forget, you've got a contract in place and 100%. So when I'm doing audits, I had one a couple of weeks ago where I must have had about 10 different DPAs from all different online platforms. So there could have been one from Zoom, there could have been one from Stripe, there could have been one from Salesforce, things like that. They are vital now, and you need to have them in place because people have the right to ask for that information. And also, if anything ever happens and a data breach ever happens and you are audited, they're going to say, well, where is your DPA? Also, anybody, if you're doing tendering, if you're doing any of these kind of, you know, government contracts, they're going to ask how you're handling data. And also, if you are using subcontractors, you've got to make sure that they are aware. The controller has to approve all the subcontractors in that, because that's their data, you know. So 100% they are vital. I will just say quickly that anybody, if you're using anybody outside of Europe, that then becomes a standard contractual clause. A DPA goes for Europe.
Right.
Anybody outside of it is a standard contractual clause.
Europe and the UK, or is the UK
Yes,
different?
sorry, apologies. I should have said that. No, UK is okay because they have an adequacy decision that lasts until next year, and I fully expect it to be extended. So it's the EU, the EEA, and anybody with an adequacy decision. Outside of that, then you have to do a standard contractual clause.
Okay, perfect. How somebody described it to me once upon a time, and I thought it made it very plain and clear to me. It's like a data supply chain. So there's always somebody who's kind of downstream from you. So my client, for example, is the data controller. I'm the data processor. But then whenever I'm, let's say, using another software in that respect, then I have to have agreement with them, because my client needs to know that I'm keeping their data safe and secure. I need to know in turn that if there's other software I'm using or other people that I'm speaking to, that they're also keeping the data safe and secure. So it's really like a waterfall effect. And I thought that was, when somebody explained it to me in those terms, I thought that made it really, very
100%. Yeah, no, and it does make it. That's actually a really good way of describing it.
So then on that note, obviously the hot topic that everybody's talking about at the moment is artificial intelligence. And what's happening is, and I'm seeing this a lot, and it's great, a lot of the big CRMs, a lot of the big marketing automation platforms and so on are kind of putting AI modules into their existing product. So again, I'm going to just actually talk about recruitment for a second, right? So some of the big recruitment platforms are putting in AI modules. An example might be that they're using the AI module to summarize a CV and do a nice little, whereas back in the day, somebody, sat down and wrote up a nice little profile about a candidate to send across to a client. Now we're using AI to do that. So they're obviously processing CVs. Now, my question is, I suppose, do we need to update our privacy policies to explain to people that there's AI in play, or is that kind of covered under the fact that, provision of services, we're happy with the, let's say, the data processing agreement we have with our software supplier? Again, that's 10 questions in one. I have a bad habit of doing that.
Yeah. I'm like, I'd wait for you to get to the end because I think there's another one in there. No. Okay, let's look at this a couple of ways. AI absolutely is massive. AI is only really kind of starting to be, it's obvious, as with everything, it starts with the big companies and it filters down to the smaller ones. And we 100%, what I said earlier, and it comes back to it, transparency. If you are using AI in any shape or form and it's getting my data, I need to know about it. I need to know what you're doing with it. So put it into your privacy policy, put it into your terms and conditions, put it into your service level agreement, put it into your contract. If it is, in fact, if it's impacting any of those areas, 100% put it in, because it's only going to get bigger. So 100% put in what, the platform you're using, why you're using it. If are the results being stored anywhere? Does anybody else have access to it? Are they being remotely wiped on it? All of those kind of things, the same way as you would with data. 100% you have to tackle it. You have to include it. This actually, again, this is another situation that happened to me. I was doing a training course with a local enterprise office. And it was to do with GDPR and business. And I had 8 people signed up for the course and 9 people logged in, because one of them was an AI, a tool that was on the Zoom. And that was the first time it happened to me. And I actually had to call everybody's attention to it, because again, it's transparency, and I had to say to them, we've got, and the person who, because it automatically logs in if you have it in use. And I had to say to them, there is a tool here, that's going to be capturing everything we're saying. It's going to be doing notes afterwards. Are you happy? Do you consent for it to be here? Because sometimes in these situations, and an island is a very small place. UK is a lot bigger. I was born and brought up in London, so it's a big place. Whereas an island, if you're disclosing anything, you can guarantee that somewhere along the line, someone knows someone who knows someone who knows someone. So and I said to them, don't disclose anything private. Don't disclose anything that you wouldn't want to be shared in public. I don't know where this data is being stored, because I don't know. I don't have the holds, ins and outs of it, and things like that. So that is what is happening now. in situations whilst we're there, an AI tool is always kind of nearby or being used or being worked for. So be open and transparent about it. There's nothing wrong with it. This is our modern technology. Just be open and transparent and say you're using it. But again, going into your privacy policy, and I meant to say this when we spoke about privacy policies earlier, your privacy policy, you should be reviewing yearly, if not twice yearly anyway. Because I always say, what I'm doing in my privacy and the services I'm offering, they change. They could change in 6 months' time. I might offer a new service that's additional to what I'm already offering. I might be working with new platforms. I might have new extensions on my systems that I'm using. So always review it and update it and make sure it's as current as it can be.
Okay. And then kind of circling back, it sort of takes us right back to the start then. So if you did want to sort of start re-engaging your existing customers and so on, that might be a nice opportunity to do it then, because you're updating your privacy policy with your new AI paragraph or whatever. So that might be a good opportunity to start engaging people.
Absolutely. Yeah, you could use it as that. 100% you could bring it in and say, because everybody's aware of kind of AI. You could also as well, like last year, there was a change to Google Analytics on people's websites as well. If you wanted to update them on that and say there was now GA4 as opposed to Google and Universal Analytics. I contacted a lot of my clients to say your policies need to be updated. This needs to be changed. You can use that then as well. It's, you know what it is? It's to do with an open and transparent relationship with your clients and the people that you have on your database. Let them know that you are obviously just, you have their best needs at heart, and that you're just letting them know that certain things have changed and certain things have been updated. And when you work with them, it was like A, but now it's moved on to B, but you would still like them to know about it. And are they still happy to work with you and be in contact with you? So 100%. Use it. You can always use it as a tool, and you can always say, also, are you aware that we offer this service and that service, which may not have been around the first time that you worked with them or the first time you gathered their information. Use it as a selling tool. Always use kind of data is so valuable to us. We're all in business for a reason. Whilst we love our jobs, if nobody's paying our bills, we can't do what we do. So use it as a sales tool, but use it in a transparent way, because you're giving them something as well. You're letting them know what's happening with their data. So absolutely. Okay,
very good. So that was sort of the end of the curated questions, and we've ended up kind of answering a number of the other questions as we've gone through as well. And I think we're literally just about on time. So how do people? So after this, I know, Eileen, when we were talking before, you'd said that you have a little legitimate interest template that's available for people that I can share with them after.
Absolutely. Yeah. Like if anybody is looking to rely on legitimate interest for pre-existing kind of clients and clients they have an ongoing relationship with, and you just want to have that there as a template to say, do you know what, I've done the test. The reason I'm working with these people is through a legitimate interest, and it gives an explanation to it. Yeah, there is a free, it's an LIA template. GDPR does like to initialize and capitalize everything. So, you're welcome to have that. And then if they want to get in touch with me, the email is at the bottom, but also LinkedIn. I'm all over LinkedIn, and, and I would be putting hints and tips up there, constantly looking at stuff. And so if people are unsure about, like, we were talking earlier about periods of retention and unsure about certain industries as to what they have, could drop me a message there, and I'll say to them, do you know what, have a look here, have a look there, and just give them a bit of guidance, because I'm so aware that GDPR can be overwhelming for people.
Yeah.
But you've got to start somewhere. You can't ignore it. You've got to start somewhere.
Yeah, definitely. All right. I think that about wraps it up. I know it's just literally touching the surface, but as you say, I think the key for me is not to be scared of it. If you have lots of data, let's use it. The purpose of having your data is to be commercial and make money. And that's what we all want to do. And that's why everybody's here on the call. So I think, use it to your advantage, but, be careful. I'm going to leave on this point. Eileen and I had been talking last week, one of the days, and Eileen said, what was it? If you're not paying attention to data protection and privacy, it's like having a car and not having tax and insurance and a driver's license.
I love an analogy. Yeah, absolutely. 100%. You would never,
and I don't want to be in the car with you.
Yeah. Yeah, you would never want to get in a car. Like, imagine if somebody gets into a car and they don't have any tax, insurance, or driving license. Why are you getting in that car? And so if your business doesn't have this in place, why would somebody engage you? Why would they work with you? Make yourself the most legitimate, roadworthy kind of the best way that you can be, and make sure that you're compliant in everything you're doing.
Yeah, definitely. I think on that point, that's a nice way to round off. So, yep, great to have everybody on the session. I'm hoping to run some more of these Let's Talk data sessions over the summer. So if people have any other kind of topics that they'd like to cover from a data perspective, data segmentation, how to create a data-driven culture, that kind of thing, certainly get in touch and with any topics that you're interested in, or indeed any questions for Eileen and I after this, and we'd love to talk to you. So thanks very much.
Thank you. It's great to see everybody. Bye-bye.